If you are a regular audience member of this podcast, you're going to remember back on December 31st, 2024, just a few weeks ago, I issued a podcast called Highland Bond Issue Shenanigans, and I interviewed Ron Greiner, who happens to be a sponsor of this podcast. I also interviewed retiring county auditor for the county of Washington in the great state of Iowa, Dan Widmer. And we talked about the shenanigans of the election, and specifically 96 votes that should not have been part of the Highland School District $15 million bond referendum, but somehow Waco School District voters got to vote on that issue. January 6th, I issued a podcast with Marcus Fedler, who is one of the Board of Supervisors for Washington County, and he talked about how this election was soured by 96 votes. He agreed with Mr. Greiner that that was wrong, and there should be a new election for the bond referendum. And Marcus actually is a citizen of Ainsworth, Iowa, so he was voting in that election as well. Neither he nor Mr. Greiner had a dog in the fight one way or another, whether the bond issue passed or was turned down. But the issue is the fact that Dan Widmer, the county attorney, the other Board of Supervisors members, all found out that this happened on Tuesday, November 5th, before the canvassing of the votes took place. Things could have been changed. On January 20th, after Mr. Greiner put up $3,000, went out and got signatures for a petition, he got what is called a contest court opportunity, and he was up against the Highland School District, and they had a impartial judge / attorney, a Tumwa-based man, oversee the proceedings. Both the Highland School District School Board had an attorney. Mr. Greiner had an attorney. They talked their case. Highland School Board tried to say that Mr. Greiner didn't file his paperwork in time, and that was enough, that the whole thing should be thrown out, and they move on and get their $15 million bond referendum. Not the case. Mr. Greiner did everything right, and Mr. Ruth, Dan Ruth, who's vice president of the Highland School Board, he was representing the school board. He, along with Mr. Greiner and with the Ottumwa-based attorney, agreed that Mr. Greiner filed on time. Where the Ottumwa-based attorney and Mr. Ruth parted from Mr. Greiner is the fact that they decided that there were enough votes from Johnson County and Louisa County that the bond referendum passed, so the Ainsworth votes don't matter, so they didn't count them. So you folks in Ainsworth never got to vote. Well, we've got some good news coming up on this, or at least I think it is, for the sake of election integrity, first of all. But before we get into that, I want to let you know this episode is brought to you by Greiner Auto Body of Washington, Iowa, using state-of-the-art techniques and decades of experience to get your car back on the road after an accident. Excuse me. Car Doctor of Washington, Iowa. No matter who Frankensteined it, they can fix and clean and customize it. McDonald Boneyard of Keota, Iowa, for all of your farm equipment and auto recycling needs. Hinshaw Trailer Sales of Richland, Iowa. You need a trailer. They've got your trailer, and they fix what they sell and don't in their full-time repair shop. Girling Repair of Winfield, Iowa. If your mower is dead, call Fred, your Husqvarna, Aaron's, and Gravely dealer. Fred also fixes and sells snowblowers. B&B Propane and the family of Jet Stops. The Dutch Market and Coffee Talk of Washington, Iowa. Dutch Market has all your grocery needs taken care of, and if you need a conference room for a business or you have a family event, they loan those out for free. So just call them and reserve that today. And Coffee Talk now has their drive-thru open. You can get ice cream there. You can get sandwiches. You can get energy drinks, baked goods, and of course, coffee. And they all present the award-winning Southeast Iowa Today. I'm John Bain, author of Christie's Journey, The Beat Goes On, and your host. Here's the neat part. What I'm holding right here, that is an appeal. It says in the Iowa District Court in and for Washington County, and this was issued on February 5th, in regard to the election contest of Highland School bond referendum, appeal from contest court to district court. Comes now, appellants, and for their appeal from contest court to district court, states the following. 1. On May 13th, 2024, the Board of Directors of the Highland Community School District called an election on a $15 million general obligation bond measure to fund improvements to the Highland Community School District. Number 2, an election on the bond measure was held on November 5th, 2024. The public measure passed with the requisite 60% of total votes cast. Number 3, on November 27th, 2024, appellants, interested persons residing in the Ainsworth precinct, appellants, filed a contest petition challenging the election results on the bond measure. Subsequently, I get those big words out, appellants filed the required bond and affidavit in support of the contest petition on December 6, 2024. Number 4, the petition asserted ballots including the bond measure were given to voters at the Ainsworth precinct that do not live in the Highland School District, and it was unknown the number of improper ballots returned and included in the total vote for the bond measure. Number 5, on January 20th, 2025, a trial was held before the contest court at the Washington County Courthouse. At the conclusion of the hearing, the contest court announced the following judgment. 1, voting 3-0, the contest court held it had jurisdiction, finding appellants timely filed the required petition, bond, and affidavit. And 2, voting 2-1, the contest court held Iowa Code Section 57.4 applied, which provides that misconduct, fraud, or election by a precinct election official is not sufficient to set aside an election unless the rejection of the vote of that precinct would change the result. Finding rejection of the vote of the Ainsworth precinct would not change the result of the election on the bond measure, and therefore declined to set aside the election. 6, pursuant to Iowa Code Section 62.20, contestants have 20 days to appeal the decision of the contest court to the district court. The appeal is timely. 7, pursuant to Iowa Code Section 62.20, the district court is to hear the appeal in equity and decide the issues anew. Wherefore, appellants respectfully request the district court to establish appellate procedures for this appeal, review the issues de novo, render a decision favorable to appellants, and for such other relief warranted under the circumstances. And that was submitted by Fink Law Firm, Sasha L. Fink, who is Ron Greiner's attorney. And you can see Ms. Fink on the January 20th episode. Breaking news, $15 million Highland bond issue passes. Ainsworth votes don't count. Well, guess what, ladies and gentlemen? They might count after all if Mr. Greiner wins when he has his day in court. And the bottom line is, if we don't have election integrity in this country, how do we have integrity anywhere else? The swamp is not just in Washington, D.C. The swamp is all around us. And if we don't clean our own backyard, we can't take care of anybody else's backyard. So let's get this right. Let's do it right. And let's make it fair. Isn't that what we want to teach the kids of the Highland School District and any other kids in any other school district? You don't get your way on a technicality. It shouldn't be that way. You should get your way because it was fair. So let's hope that happens. Thank you for watching. I really do appreciate it. Please, if you like this episode, give it a like. Make sure to follow and subscribe. It's free. Also, thank you to my sponsors, Greiner Auto Body, Car Doctor, McDonald Boneyard, Hinshaw Trailer Sales, Girling Repair, B&B Propane, and the family of Jet Stops, the Dutch Market, and Coffee Talk. I'm your host, John Bain. Stay friendly, Southeast Iowa.